In the previous section, we examined how brokers earn and collect compensation across different types of real estate transactions. The foundation of those rights rests not only on statutory requirements under ARS Title 32, but also on case law that has shaped how Arizona courts interpret real estate employment contracts. These judicial decisions provide guidance on when a commission is earned, what constitutes proper performance, and under what circumstances a broker may or may not recover compensation. This section applies both Arizona revised statutes and landmark cases to real-world scenarios, bringing legal principles into practical context for brokers and licensees. Arizona law begins with ARS, paragraph 32 151 Odso 2, which mandates that all real estate employment agreements be in writing, signed by all parties, and include a definite expiration date and terms of compensation. ARS, paragraph 32 155, further prohibits any licensee from accepting payment directly from a client or another broker outside their employing broker's supervision. These statutes form the bedrock of broker-client relationships and are consistently reinforced in Arizona court rulings. Mealy v. Orlick, 1978, established that a broker cannot recover compensation without a valid written employment agreement. In this case, the broker attempted to collect a commission on an oral promise by the seller, arguing that performance entitled him to payment. The Arizona Supreme Court disagreed, emphasizing that the statute of frauds, ARS paragraph 44 10017, requires written contracts for compensation related to real estate services. This case underscores the principle that even if a broker fully performs, no commission can be lawfully enforced without a written agreement signed by the party being charged. Brokers today should take this as a warning that verbal assurances or informal emails are insufficient substitutes for properly executed contracts. Larson, Hagstrom, and Associates, Anchor versus Jeffries, 1985, reaffirmed the need for precision in defining when commission is earned. In this case, the broker procured a buyer who agreed to the seller's terms, but the sale did not close because the seller refused to complete the transaction. The court ruled in favor of the broker, holding that since the broker produced a ready, willing, and able buyer under the agreed terms, the broker had fulfilled their contractual duties. This decision aligned with the reasoning in Mann v. Glaze, 1984, and clarified that once a broker performs according to the employment agreement, compensation cannot be withheld due to the client's unilateral refusal to close. Demand v. Foley, 1970, addressed the importance of good faith and the timing of commission payments. In this case, the broker's contract stated that payment would occur upon closing. The deal fell through, but the court ruled that because the seller acted in bad faith to avoid paying commission, the broker was still entitled to compensation. The key lesson from Demand versus Foley is that parties cannot use the failure of closing, especially one they caused, as an excuse to deny payment when the broker has performed in good faith. This reinforces that lawful compensation depends not only on contract terms, but also on ethical conduct. The closest statutory alignment is ARS, paragraph 32 125, which governs a broker's right to compensation and requires that commission be based on a written agreement, reinforcing that compensation is contract-based but enforceable when the broker has performed as agreed. In addition, ARS, SERF 32 121-02A, requires that real estate employment agreements clearly state material terms, including when compensation is earned and payable, which directly parallels Demand v. Foley's focus on contractual timing of commission payments, e.g., upon closing. Nash v. Gore, 1963, emphasized the broker's duty of honesty and fair dealing when pursuing compensation. In that case, the broker concealed material facts during a negotiation to secure a higher commission. The Arizona Supreme Court held that any fraud or misrepresentation by a broker forfeits their right to compensation, regardless of whether the transaction closes. This principle remains critical under Commissioner's Rule R4 28-1101A, which requires honesty, fairness, and disclosure in all real estate dealings. A broker who breaches fiduciary duty cannot benefit from that breach, no matter how much work was performed. The Arizona revised statutes that align with and reflect this principle are primarily ARS. Paragraph 32-151, R2, and ARS. Paragraph 32-155, ARS. Paragraph 32-151.02 requires that listing and employment agreements be in writing and clearly set forth all material terms, including how and when compensation is earned, allowing parties to contractually require a closing if they choose. ARS, paragraph 32-155, governs a broker's right to compensation and requires a written agreement, authorizing payment, reinforcing that entitlement to a commission depends on the terms of the written contract. Clark v. Ellsworth, 1947, remains one of Arizona's earliest and most cited cases concerning the ready, willing, and able doctrine. The court determined that a broker earns commission when they produce a buyer who meets the terms of the seller's offer, even if the seller later changes their mind or refuses to sell. This case has been repeatedly referenced to affirm that brokers are compensated for performance, not merely for a closed transaction, unless the agreement specifically conditions payment on closing. In modern practice, most Arizona brokers include payment upon closing language to avoid ambiguity, but Clark v. Ellsworth continues to provide guidance for cases where contract terms are less defined. The case reinforces that a broker's right to compensation depends on the terms of the listing agreement, and that, in a non-exclusive arrangement, the mere fact that the broker's activities helped identify a purchaser does not automatically entitle the broker to a commission. Muhammad v. Robbins, 1975, addressed disputes between cooperating brokers and reinforced the rule that all compensation must flow through the employing broker. In that case, a salesperson attempted to collect a commission directly from another broker without the involvement of their employing broker. The Arizona Court of Appeals ruled this action unlawful under ARS paragraph 32, Binam Fodder 5. The case reaffirmed the structure of accountability. Salespersons are agents of their brokers, not independent entities in compensation matters. This ensures oversight, trust fund management, and compliance with ADRI's record-keeping standards under R4 28-1103. Applying case law to modern scenarios. Consider a scenario where an Arizona broker produces a buyer who agrees to all of the seller's terms, but the seller later decides not to sell. Under Larson, Hagstrom, and Clark v. Ellsworth, the broker has fulfilled the employment contract and earned the commission. If the seller refuses to pay, the broker may pursue payment through civil action, provided the agreement is in writing. In another situation, imagine a salesperson who finds a buyer and negotiates a sale but receives payment directly from the title company instead of through the broker. Under Muhammad v. Robbins, this would constitute a violation of ARS, paragraph 32-155, and both the salesperson and the broker could face disciplinary action from the ADRI. A salesperson may receive their earned commission through the title company, but there are forms that need to be completed per brokerages, and the broker needs to give permission for the title company to cut a check to the agent directly. Finally, if a seller conspires to delay or sabotage the transaction to avoid paying the broker, demand vis Foley would apply, making the broker still entitled to their commission due to the seller's bad faith conduct. Review summary. The consistent theme across these statutes and cases is that compensation follows lawful performance, but only within the bounds of written, ethical, and supervised agreements. Arizona's case law reinforces that brokers earn commissions through performance, not promises, and that both honesty and written documentation are non-negotiable. Mealy v. Orlick, reminds brokers of the necessity of written agreements. Larson Hagstrom and Clark v. Ellsworth confirm the right to payment upon performance. Demand v. Foley upholds fairness in the face of bad faith. Nash v. Gore enforces ethical conduct. And Mohammed v. Robbins strengthens the rule that payment flows through the employing broker. These precedents, together with ARS, Paragraph 32 to 151.02, 32 to 155, and 44 to 1017, form the legal and ethical backbone of broker compensation in Arizona. Discussion: how does Mealy v. Orlick reinforce the importance of written employment agreements? Answer: it established that without a written agreement, a broker cannot recover compensation, even if the broker fully performs, because oral promises violate the statute of frauds. Why did the court in Demand v. Foley rule in favor of the broker, even though the transaction didn't close? Answer: because the seller acted in bad faith to avoid paying the commission, and Arizona law prevents parties from using their own misconduct to escape contractual obligations. How does Mohammed v. Robbins protect the integrity of broker supervision and compensation? Answer: it ensures all payments go through the employing broker, preserving accountability, compliance, and consumer protection within brokerage operations. Supporting sources and key case law, Arizona Revised Statutes, Paragraph 32 to 151.02, 32 to 135, and 44 1017. Commissioner's Rules R4 28-1101 and R4 28-1103 Mealy v. Orlick, 1978. Larson, Hagstrom and Associates, Inc. v. Jeffries, 1985. Demand v. Foley, 1970. Nash v. Gore, 1963. Clark v. Ellsworth, 1947. Mohammed v. Robbins, 1975.